We have new documents, including something that was finally unsealed. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Now, before we get into the actual one that we're going to go over and read, I just want to remind you guys that this is the document that in the motion hearings, we heard Ann Taylor giving some sort of like advice to Bill Thompson about how before this was to be unsealed and made public, that there was a portion of it or a sentence, like one sentence, according to Ann Taylor, that she recommended that the state like redacted before they released it public. No idea what it could be. I sort of glanced over the document, but as you guys know, I like to react to these things for the most part in real time. So all that I've done so far is skim. I don't know the details, but I also have a couple other things placed in chronological order that I wanted to show you guys before we got to that document, because it shows us what led up to this finally being unsealed. What I wanted to show you guys was the order of things. So this is March 22nd, the order prohibiting contact with prospective jurors until further order of the court. This is where the judge said, okay, this is going to halt. Okay, this is before the last two hearings that we had. Then we have this one, which is the temporary sealing of this motion that's now public that we're going to get to. Now, this is another motion for the unsealing of this exact document, and this was actually posted to the file on 3/29. Then on 4/4 is where we have the stipulated motion to file all attachments and requests under seal. So anytime anything gets filed from now on, and we've gone over this, but I'm just going to go over it one more time. Pretty much at this point, anything that gets filed is going to automatically be sealed. And if it's going to be unsealed, there's going to have to be a special request like this one that we're going to go over. Now we have the stipulated motion for the unsealing, and this is dated on 4/15. Now we have it being approved for it to be unsealed, and this was filed my birthday yesterday, the 18th. Now we have the official redacted document. Now this is like 6 pages, but how many is it to actually read? Like 3.5, pretty much. Okay, we're gonna read this. This right here is strange to me, why it's all of a sudden like a different text. I can't say all of a sudden, we've never seen this before, but it's a different text. Like, I understand they needed to redact this portion right here, but why did the entire everything change? Like, why all of a sudden is everything in bold and crooked? Like, their editing capabilities to handle things, they need to up their game. But okay, let's go ahead and read this and see what is so special about this, because we've already handled all of this. Not like handled it. We still don't know when, if, and what the stipulations could be for if the defense is going to be allowed to continue this survey. We don't know that yet. We are still waiting on the judge to give a decision on that portion of this whole thing. But this is technically what was filed in the very beginning of this, because see, this is dated the 22nd of March. So this is like the original paperwork. Okay. Motion for order prohibiting contact with prospective jurors absent leave of court. Comes now the state of Idaho by and through the Latell County prosecuting attorney, and respectfully moves this court, pursuant to this court's revised amended non-dissemination order, for an order prohibiting the defense from contacting prospective jurors about this case without first obtaining permission from the court. The state recently became aware of a telephone survey being conducted in Latell County related to this matter, when some of the recipients of such calls contacted the prosecuting attorney's office to express concern about the survey. The Moscow Police Department has also received calls expressing concern about such calls and questions as to whether the police department was responsible for the survey. See Exhibit A, Moscow Police Department reports. Now, we did hear beforehand that there was police reports about these calls. Just this week, the state came into possession of a transcript of one such call. See Exhibit B, something else most of this we're going to know already, but I'm just curious as to why they wanted this all of a sudden public and unsealed, because so far, and just from like looking at what I'm looking at while I'm talking to you right now, I don't see any new info. I don't know. Okay. State came into possession of a transcript of one such call, see Exhibit B, and a summary from another who received such call, see Exhibit C. So we've got the transcript, we've got a summary from another person, and then we have a police report that is 3 separate reports, items regarding the problem. Not problem, regarding their issue. Based on the transcript, the survey goes beyond soliciting information and provides those being called with specific information about the case. For example, the person conducting the survey asked the following questions. Have you read, seen, or heard if Bryan Kohberger was arrested at his parents' home in Pennsylvania? Have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Have you read, seen, or heard that DNA found on the knife sheath was later matched to Bryan Kohberger? Have you read, seen, or heard if Bryan Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred? Exhibit B. The state raised the issue with defense counsel and then met with defense counsel on March 21st of 2024. Defense counsel confirmed that the defense retained a jury research company to assess community knowledge and opinions about the case. The state expressed its concerns and notified defense counsel that it would be raising its concerns with the court. The state requested that the defense halt further communication with potential jurors until the court could weigh in. Defense counsel represented that the surveys were already almost done. So on March 21st, whenever they contacted the defense about the survey, the whole 400 was not finished just yet. But in between them filing with this, in between March 21st and them filing with the court and the judge putting in the halt of the survey, and where was that? The 22nd. That's like the very next day. So on the 21st, they weren't completed, but the very next day, on Friday, whenever this was filed, it was completed. Was the 22nd of Friday? Yeah, it sure was. How are you almost done, but then 24 hours later, you're done? Interesting. In Hoosers. The state's concern with the survey commissioned by the defense is that it may violate this court's revised amended non-dissemination order in a manner that could make selecting a jury in Latell County more difficult. As relevant here, the order expressly prohibits any agents of the prosecuting attorneys and defense attorneys, and that's something that Bill Thompson brought up in the hearing, that this survey company was an agent of the defense, and technically he's not wrong, from making any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. The order also prohibits the disclosure of any information a lawyer knows or reasonably should know is likely to be inadmissible evidence in trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Despite these expressed prohibitions, the defense commissioned a survey that included potential jurors in Latell County and, as part of the survey, conveyed the identity or nature of evidence expected to be presented at trial, and then this. Then this huge redaction of what seems to be at least 3 lines, right? If you take the measurements, maybe 4.5-ish. Let's see, 1, 2, 3, 4, 5. So 4 full lines in this. That's a lot of information. More problem still, the Defense's Commission survey also included in the survey specific rumors, which the defense should have known are likely to be inadmissible in trial. For example, the question that implies that Bryan Kohberger had followed one of the victims on social media. So that is telling you right now that likely to be inadmissible at trial is the fact that Bryan was following the victims on social media. Now, that either tells me that they legit know that he wasn't following any of the victims on social media whatsoever at all, or he was following them after the crime because he's a criminal justice student in the area. That matters. That matters. And that's just me assuming. That's just me assuming. The survey also pointed respondents to out of courtroom coverage of this case that almost certainly contains more rumors and misinformation that would not be admissible at trial. Exhibit B, Part 6 states, have you listened to any true crime podcast or watched any shows on YouTube that covered this case? For example, the King Road killing. Okay, but that's media. That's media. And that's a question that you're going to ask a juror anyway, right? Like when it comes to actually sequestering the jury pool, isn't that going to be a question that gets asked? Like you can know about the case, but you can't have like gone in there and binged every single freaking documentary or docuseries that's been created on this case, because then you're definitely not going to be able to sit on the jury because you already know a lot of BS. Okay? I don't see a problem with asking that question. I don't. That tells you the amount of people, or I mean, it gives you an assumption to the ratio or percentage of people in the area that are not just getting their information from local news stations, that are getting it from wherever they're claiming they're getting it from. I don't see a problem with that question. Given that the survey of potential jurors seems to violate the order, the state respectfully requests this court enter an order specifically prohibiting the defense from contacting potential blop. It cuts off. Blop. I don't know why I just said that. I don't think I've ever said that word before in my life. Blop. But it cuts off and like finishes down here. So they couldn't even go into the original copy of this document and just used a text box or something to cover this. But this also tells me that they did something else. Because this, like right here, should have been the end of the page, and these two sentences right here should not even be here. So something else was changed. Something was taken out. At least 2 lines had to have been taken out, right? Or something. This is like 2 different versions of this, like pieced together, because even if they would have gone in and edited this, like this is still 2 different versions, because there's no reason for these sentences to be. Man, this is some crappy work. Y'all could be a lot more professional. I'm just saying. Anyway, bottom of the thing just states, take away their ability to do this survey, please. And then they submitted it. But yeah. So the only thing besides this being super sketchy, because what else could they possibly tell us at this point? Besides what they've already told us, that the social media stalking and the social media following and the stalking allegations were false. What else could have been so important that Ann Taylor herself was like, hey, bro, you might want to redact that before you release it to the public? And I can sort of see why they didn't want this out there, like just out in the freaking nether over the weekend. I completely freaking get it, because that information about him not following one of the victims on social media is in here. Now, the whole stalking allegation thing is not in here, but the social media one is. The stalking allegation one was what was yelled about in court. Unless maybe that is what is blocked off right here, but it's been talked about so much now, I don't see the point to that. So that's got to be something else. Ooh, curious, bro. But that's it, you guys. Yeah, I don't see. Other than the whole social media thing, we heard more details in court. So I don't know why this even needed to be sealed. Other than that, there's really nothing in here that's too crazy, but I could see why they didn't just want that out there before we went to court and heard everything else. But I guess that's it. So let me know what you guys think down in the comments. If you like the way that I present this information and give my opinion, please do not forget to leave a like on your way out and subscribe to the channel if you were not subscribed already. See y'all.